Welcome to part 5 of my free YouTube course about franchise law in Ontario. As we continue learning about Ontario's Arthur Wishart Act, otherwise known as the Franchise Disclosure Act, in this chapter, you'll learn about the franchisor's obligation to disclose certain specific information to a potential franchisee before signing a deal. This concept is found at Section 5 of the AWA, and this section of the legislation is divided into several subsections. Section 5 of the Arthur Wishart Act is arguably one of the most important, if not the most important, section of this legislation. But think about it. Franchising often looks like a shortcut to success. A small investor sees a big, recognizable brand and thinks, if I just follow their system, I can't go wrong. It feels safer than starting a business from scratch. But here's the problem. Behind that polished logo and friendly marketing is usually a large corporation with lawyers, accountants, and years of experience negotiating contracts. The average person buying a franchise doesn't have any of that. There's a massive imbalance in power, information, and resources. Without laws to protect small investors, it would be incredibly easy for big franchisors to take advantage of people. They could hide ongoing lawsuits or serious financial problems behind glossy branding, downplay how many of their other franchise locations have failed, or make vague promises about support that never really materialize. Worse, they could bury harmful clauses deep in long legal agreements, like requiring you to spend tens of thousands on renovations, or allowing them to open a competing location right down the street. Once you sign and hand over your money, you're often locked in. And at that point, finding out you weren't told the whole story doesn't help much because you've already taken the risk. That's why laws like the Arthur Wishart Act matter. They require franchisors to come clean before you commit. They force companies to disclose the kind of information that could change your mind or at least help you go into the deal with your eyes open. These laws aren't designed to punish honest businesses. They exist to prevent dishonest ones from preying on people's hopes and dreams. When you're investing your life savings into a franchise, you deserve transparency. You deserve a fair shot. And that's exactly what this kind of legislation is meant to provide. So let's take a deep dive into what the law actually says. You can see that subsection 1 of section 5 is quite long, so you can pause the video here if you want to read it. I'm going to provide a plain language explanation of this subsection instead of just reading the law to you. Before a franchisor can get you to sign anything or hand over any money, they are legally required to give you a document called a disclosure document. This document contains all the important information you need to decide whether or not to buy the franchise. The law says you must receive it at least 14 days before doing either of the following two things, whichever happens first. First, if the franchisor wants you to sign a franchise agreement, or even any other type of agreement related to the franchise, then they must give you the disclosure document at least 14 days in advance. This gives you time to read it, understand it, and get legal advice if you want, before making any commitment. I've personally seen situations where people just signed an agreement without even reading the disclosure document, and that mistake ending up becoming a very expensive problem later on. Second, if the franchisor asks you for money, then they must also give you the disclosure document 14 days ahead of time, unless the payment meets all of the following conditions. First, if the payment does not exceed 20% of the franchise fee to a maximum of $100,000. This cutoff is set by Section 7.1 of Ontario Regulation 581/00. Second, if the payment is fully refundable with no deductions. And third, paying it doesn't lock you into anything. In other words, you're still free to walk away without signing a franchise agreement later on. If all of those three conditions are met, then the franchise is allowed to ask for payment without following the usual disclosure timelines. In short, subsection 1 of section 5 is about giving you time to make an informed decision before committing legally or financially. It prevents franchisors from pressuring you into rushing, signing, or paying without seeing the full picture. Sometimes, before a full franchise agreement is signed, the franchisor and prospective franchisee want to get a few things sorted out first. Subsection 1.1 of Section 5 of the Arthur Wishart Act recognizes this and makes a practical exception to the 14-day rule. This section says that the 14-day waiting period does not apply to certain types of early-stage agreements, but only if those agreements are very limited in scope. Specifically, a franchisor and a prospective franchisee can sign an agreement before the disclosure document is given, as long as the agreement only includes terms that do one or more of the following. First, it can require the prospective franchisee to keep information confidential. This is useful for franchisors who want to protect sensitive business details while discussions are ongoing. Second, it can prohibit the use of that information, meaning the prospective franchisee can't turn around and use what they've learned to start a competing business or share it with others. Third, The agreement can lock in a specific location or territory. This helps franchisors avoid losing prime locations to other prospects while negotiations are happening. So in plain terms, this rule allows both sides to handle some basic groundwork, like signing an NDA or reserving a territory, without triggering the 14-day countdown for full disclosure. But the moment the conversation shifts towards signing the actual franchise deal or paying real money, that's when the 14-day disclosure rule kicks in. Now, with that being said, subsection 1.2 of section 5 puts limits on the exception we just talked about. It acts like a warning to franchisors. You can't abuse the early stage agreement loophole to sneak in unfair or overly broad confidentiality rules. Even though subsection 1.1 allows some early agreement, like NDAs or territory reservations, before giving the disclosure document, subsection 1.2 says that if the agreement goes too far, then the full 14-day disclosure rule still applies, even if you call it just an NDA. Here's what crosses the line. First, if the confidentiality clause tries to cover information that is already public or that becomes public in some other legal way, that's not allowed. Also, if the information is shared with someone legally, like with consent or accidentally through no one's fault, the agreement can't try to keep it secret anyway. If it does, then it's no longer a simple NDA, and full disclosure must be given before signing it. Second, and this is really important, if the agreement tries to stop a franchisee from talking to other franchisees in the same system, to franchisee associations, or to their own professional advisors, like a lawyer or accountant, that also crosses the line. A franchisor can't stop someone from doing basic due diligence by cutting off access to people who might give honest feedback or professional advice. So in short, if the so-called NDA goes beyond simple, reasonable confidentiality and tries to create overly broad restrictions, the law treats it like a more serious agreement, and that means the 14-day disclosure requirement would have to be followed. Subsections 2 and 3 are pretty straightforward. Subsection 2 explains how the disclosure document can be delivered. It says the franchisor can give it to the prospective franchisee in person by registered mail or by any other method that's officially allowed by regulations. The key idea is that the method must be reliable and trackable, no slipping it under a door or casually emailing pieces of it. Subsection 3 makes it clear that the disclosure document must be delivered all at once as one complete package. Franchisors can't break it up and send it in parts over several days. The law wants the prospective franchisee to receive everything they need to make an informed decision in one shot, not piecemeal. Subsection 4 explains what must be included in the disclosure document, and it's essentially the heart of the franchisor's legal duty to be transparent. The law says the disclosure document has to include all material facts. That means anything important that could affect a prospective franchisee's decision to invest. I can't stress enough how comprehensive the law gets with what is considered to be a material fact, and therefore needs to be disclosed to potential franchisees. The list of things is incredibly detailed. If we flip over to Section 6 of Ontario Regulation 581/00, you'll see a list of 18 things that need to be in there. I'll include a link to this regulation, and you can take a look at Section 6 for yourself, but I'll provide a brief overview for the purposes of this video. First, the disclosure document must give a clear breakdown of all costs a franchisee can expect when starting the business. This includes upfront fees like deposits, as well as estimates for things like inventory, renovations, equipment, and leases. If the franchisor gives operating cost estimates or profit projections, they must also explain the assumptions behind those numbers and show where supporting data can be reviewed. This protects buyers from being misled by overly optimistic numbers that have no real basis. Next, it must explain how financing works if the franchisor is offering any kind of loan or payment plan, either directly or indirectly. It should also describe any training or assistance that will be provided, whether it's mandatory or optional, and who pays for it. If the franchisee is required to contribute to an advertising fund, the document has to outline how that fund was spent in the past 2 years and how it's expected to be spent in the current year. It also needs to say whether the franchisor will provide reports showing how the advertising money is used. The disclosure must also describe any restrictions the franchisor imposes, such as whether the franchisee must buy products or services only from certain suppliers, what kinds of goods or services can be sold, and who the franchisee is allowed to sell to. Next, the franchisor must disclose if it receives volume rebates or kickbacks from suppliers and whether these are shared with franchisees. The document also needs to state who owns the trademarks, logos, and brand names, and what licenses or permits are needed to operate the franchise. It must also be clear whether the franchisee is expected to be personally involved in running the business, or if it's a corporation, whether one of the principals must do so. If the franchise grants an exclusive territory, the franchisor must explain the rules around that, including whether the exclusivity depends on sales performance or other conditions. The franchisor must describe their policy on how close other locations can be, including locations run by others under the same brand, or even similar ones run under different brands by the same company. This is important so franchisees know if their territory might be cannibalized by the franchisor later. Finally, there must be a list of franchises that closed in the past year, along with reasons for each closure, whether it was a termination, a non-renewal, or a voluntary exit. They must also provide a directory of existing locations in Ontario, or the nearest 20 if fewer than 20 exist in the province, so prospective franchisees can talk to current or past operators and get a clearer, unfiltered view of how the franchise actually operates. And they must include any rules around renewal, termination, and transfer of the franchise. Next, it must include financial statements, and not just any financials. They have to be prepared and presented the way the law requires. These statements give the franchisee a sense of the franchisor's financial health and stability, so they're not buying into something that's on the verge of collapse. The document must also include copies of all agreements the franchisee would be expected to sign, not just the main franchise agreement, but any other contracts too. That could include lease agreements, supply agreements, or anything else tied to operating the franchise. It also has to contain specific prescribed statements, standard language designed to help the franchisee understand their rights and risks under Ontario law. These statements are meant to protect people who may not have legal or business training. Finally, the franchisor must include any other information or documents required by regulation. This gives the government flexibility to update what's needed in the disclosure document over time, without changing the Arthur Wishart Act itself. In short, this section ensures the prospective franchisee gets a clear, complete picture of what they're signing up for before they commit. Moving on to subsection 5 of section 5, this section deals with what happens if something important changes after the franchisor has already given you the disclosure document, but before you've signed the franchise agreement or paid any money. The law refers to this as a material change, meaning any new fact or event that could reasonably affect your decision to move forward with the franchise. If a material change happens, the franchisor is legally required to give you a written statement explaining what changed. This isn't just good practice, it's the law, and the franchisor must give you this update as soon as possible after the change occurs. Timing is critical. You must receive this written notice before either of two things happens. First, before you sign the franchise agreement or any other related agreement, unless it's one of those early stage agreements allowed under subsection 1.1, like a confidentiality agreement or territory reservation. Second, before you pay any money toward the franchise, except for a small refundable deposit that doesn't bind you to the deal and falls within the limits set out in the law. The idea here is simple but important. Franchisors can't quietly let major developments slide past you after they've handed over the disclosure document. If something significant changes, like a lawsuit, a leadership shakeup, or financial trouble, you deserve to know about it before making a serious commitment. This part of the law is designed to keep the playing field fair and the decision-making process informed. It ensures that what you're basing your decision on reflects the current state of the franchise, not outdated or incomplete information. Subsection 6 is pretty simple, and it says that all information in a disclosure document and a statement of a material change shall be accurately, clearly, and concisely set out. In other words, you can't bury people in fine print that is needlessly wordy and hard to understand. The idea is that the disclosure document should actually be something that the franchisee and their lawyer can understand. Now, if you've made it this far in the course, or if you've watched any of the other playlists on this channel, you should already expect that the law always has a million exceptions to every rule. Well, the disclosure requirements under this part of the law are subject to a boatload of exceptions. Subsections 7 and 8 describe situations where a franchisor does not have to provide a disclosure document under Section 5. In other words, there are specific types of franchise deals where the usual disclosure rules don't apply, either because the risks are lower or because the people involved are already well-informed or experienced. First, subsection 7A says the rules don't apply when a franchisee, not the original franchisor, sells their own franchise to someone else. As long as the franchisor isn't directly involved in the sale, the seller isn't secretly a representative of the franchisor, and the franchisee is doing it for their own benefit. This even includes master franchises if the entire territory is being transferred. Subsection 7B creates an exemption for someone who is or recently was a senior insider, a director, or officer of the franchisor or its associate. If they've been in that role for at least 6 months and are either still in it or left recently within the past 4 months, then they're considered to have enough inside knowledge and experience to not need a disclosure document. Subsection 7C allows an existing franchisee to buy an additional franchise without disclosure, but only if it's substantially the same as their current franchise and there's been no material change in the business since they last signed or renewed their agreement. Subsection 7D applies in special legal situations, for example, if a franchise is being transferred by a court-appointed trustee, receiver, or executor as part of an estate, bankruptcy, or other legal process. In those cases, a disclosure document isn't required either. Subsection 7E is about very small in-store franchises. If someone is going to sell products or services through a franchise that forms just a small part of a larger business they already run, and that part is expected to make up only a small portion of the business's sales below a prescribed percentage, disclosure isn't required. Subsection 7F exempts renewals or extensions of franchise agreements, but only if there's been no break in operations and no material change in the business. The idea is that if nothing has changed and the franchisee is just continuing on, a new disclosure document isn't needed. Subsection 7G lists a few miscellaneous low-risk scenarios, such as if the franchise requires only a very small initial investment, if it's a short-term franchise, less than a year, with no non-refundable franchise fee, or if the franchisor is already subject to disclosure rules under Section 55 of the Federal Competition Act, which governs certain types of franchise-like relationships. Finally, subsection 7H creates an exemption at the other end of the spectrum, very high investment franchises that go above $3 million. The thinking here is that if someone is putting in that much money, they likely have the legal and financial advice needed to protect themselves without mandatory disclosure. Subsection 8 clarifies one key point about the first exemption. It says that if a franchisor only has the right to approve or reject a resale, or charges a reasonable transfer fee, that doesn't mean the deal is considered to be effected by or through the franchisor. So those limited types of involvement won't cancel the exemption for private sales between franchisees. In plain terms, this section recognizes that not every franchise deal needs the same level of protection. If the buyer is already knowledgeable, the investment is minimal, or the situation is unusual, like a court-ordered transfer, the law gives some flexibility by waiving the disclosure requirement. Congratulations, you've completed Part 5 of this course about franchise law in Ontario. In the next video, we'll talk about Section 6 of the Arthur Wishart Act, which deals with a concept known as rescission, involving certain situations where a franchisee can void a franchise agreement and walk away even after signing. Don't forget to subscribe. I'm Ryan Keeney, and thanks for watching. I'll see you in the next video.